Oh, hey friends, Josh Yeager, the Will Whisperer, out on a drive in Palm Springs, not my hometown, but the place that I'm drinking coffee right now. I don't have my buddy Dodger with me, unfortunately. He's at the ranch in Santa Barbara hanging out with his buddies because dogs like Dodger aren't welcome by people in these fancy places. So I thought we'd talk today about the interesting issue of notice of death or notice of administration that is required by the trustee after mom or dad has died. So we're looking now at California Probate Code 160617, 16061.7, subparagraph H. I think that's what it is, but I'm not positive. And that section says, after mom and dad die, you need to tell all of the people in the trust, those are called beneficiaries, you have to give them notice that mom or dad has died, and you have to give that same notice to any heirs that are not noted in the trust. So what you do is you go through the trust instrument, you say, okay, who is noted here as somebody that is supposed to take assets under the trust? Eldest daughter, eldest son, great, grandkids, great. Everyone gets notices that mom or dad have died. And a little bit wonky, you also have to do this to heirs. Heirs may not be noted in the trust. So an heir is somebody that would take assets from the settlement of the estate if there wasn't a trust. So this might be cousins or nephews. So we've got to do some thinking on who is supposed to get this letter. Letter goes out to everyone, says, hey, mom or dad dies. It's kind of a stupid letter because they were probably at the funeral. But that's the rule. And so that's what we're going to do. Ooh, I wonder if I could go in. Nah, I probably shouldn't go in there. So we got to send the letter out to everybody. And the purpose of the letter is to give them an opportunity to read the trust document that the trustee is going to administer. Now, here's kind of a crazy thing. The statute just says you have to give the recipient the opportunity to ask for a trust document, and if they do ask for the trust document, that can add another 60 days onto this waiting period. But what we're trying to do for them is give them 120 days, that's what the statute says, 4 months, to have the opportunity to read the document and then decide, is this the right document? Am I going to contest this trust and make an argument, oh no, grandpa wrote something else later. This isn't the right trustee, you got the wrong document. Or there was coercion. Grandpa set this up, but somebody had a gun to his head, so we shouldn't approve it. Or there were subsequent gifts that you should know about or subsequent writings. So it's an opportunity to challenge. That's why we're doing this, is to give the whole family an opportunity to challenge and to cut off their ability to come back years later. So they got 4 months to challenge. Either this is the right trust document or it's not. If it's not the right trust document, now's the time to say something about it. Now, statute says, okay, everybody, grandpa's dead, you're an heir, or you are a beneficiary named under this trust. You've got 120 days to challenge the trust document, but the statute doesn't say that you have to include the trust document in this letter. It says that they have to request the trust document, and if they do request the trust document, then they get another 60 days on top of the 120 days. So this whole flipping thing goes on and on. Like, you're not supposed to start the administrative process. You're not supposed to start changing assets or titles of anything. Here, we're going to go illegally on the course. You're not supposed to do anything until this time period elapses, until these beneficiaries have had an opportunity to express, yeah, this is the right trust document, go ahead and administer, or no, there's another doc you should know about. So, tips and tricks from the Anados Law fellas. How can we make the administration go twice as fast at half the cost with lower risk? Well, here's a trick. When you're doing the notice of administration or notice of death, include the trust document, because they have to review it anyway. And why would we add another 60 days on top of the 120 days to even get started, to get to the starting line of this administration? So A, include the trust document. B, include a letter that says, yeah, I'm the beneficiary under the XYZ trust. I have received a copy of the trust document. I've reviewed the trust document. this is my understanding of what Grandpa's testamentary intent was. Go sign the piece of paper and go ahead and start the administration. You don't need to wait the 120 days or the 120 days plus 60 days. I am convinced that this is the right document. So if you do that, if you give them the notice of administration, which you have to do, and bring to their attention that they have 120 days plus 30 if they request the trust doc, or plus 60 if they request the trust doc. But you give them an opportunity to sign off. You give them an opportunity to say, no, this is it. I'm good. Let's roll. Then that can cut down the time of the administration significantly. So that's a little tip and trick for you from the fellas at Ananos Law. Our website is trustyhelp.com. Trusty-help.com. And happy estate settlements. Ciao.